appear in this matter for the appellant. My learned friend, Mr. Randall, appears for the respondents.
Thank you.
Subject to your lordships, I propose to address 4 topics in my submissions this morning. First, I propose to show your lordships the arbitration agreement, the award, and a small number of other core underlying documents. And that's just in order to put the appeal into context.
Thank you.
Second, I will take your lordships to the key provisions of the Arbitration Act, dealing with the status of arbitration awards. Third, I will explain why I respectfully submit that the learned judge erred in concluding that the parties are able to agree, within section 57 of the Act or otherwise, that awards produced by the tribunal can be changed at any time. And fourth, my lords, I will deal with what the consequences are if the parties have sought to agree a term that the Act does not allow them to agree. Before I take you to the underlying documents, my lords, I just want to make one overarching point by way of introduction. At its heart, the issue that arises on this appeal is this. On the learned judge's analysis, which is adopted by my learned friend, it is possible to have a valid and effective arbitration agreement, which first might allow the arbitrators to amend their award at any time, and which second might allow the arbitrators to make changes to an award which they have made, not just of the slip rule type, but changes which go to the very heart of what was originally decided. It would, in my respectful submission, be very surprising if that were to be correct, my lords, and I will come to the detail of why the appellant says it is not correct later in my submissions. If I can, for now, turn to the first of my 4 topics. I wanted to start by showing your lordships the key documents. If I can begin with the arbitration agreements. There are 2 such agreements. The first is contained in a share purchase agreement dated June 2019. The relevant extracts are in the core bundle, tab 13, beginning at page 108.
108.
108.
Thank you. Yep.
My lords, this is a share purchase agreement by which my client agreed to sell his shares in a company called NetPet to the respondents. The arbitration agreement is in clause 22.2, that's page 110 of the core bundle.
Yep.
Perhaps I can just read that to you.
Oh, you don't need to read it out. I mean, we've read it all carefully. Do highlight those clauses that you want to sort of emphasise, but there's no need to read the whole thing.
Thank you, my lord. The key point here is that by this agreement, the parties have agreed that any disputes arising from the share purchase agreement will be finally resolved by arbitration by the Beth Din, in accordance with the rules and procedures of the Beth Din, and that judgment upon the award may be entered in any court having jurisdiction thereof. At clause 22.1, immediately above that, the agreement provides that the share purchase agreement and any disputes arising out of it are to be governed by English law. Beth Din is defined on the previous page of the core bundle, page 109. It's the second definition from the bottom on that page, and it's the Beth Din of the Union of Orthodox Hebrew Congregations in London. So this is to be an English-seated arbitration, my lords.
Was this drafted by lawyers for the 2 parties?
I'd have to check that,
Okay.
my lord. Yes, I'm instructed it was.
Yeah. So this was before the Beth Din became involved?
Yes.
This is what the parties agreed themselves, yes. Okay.
Exactly, my lord. About 6 months after this agreement was signed, a dispute did arise about the payments due under the SPA.
Because they were split into sort of instalments.
Yes.
Yeah.
So those clauses, my lord, are not in the bundle. Nothing turns on what precisely they say. They are summarised just for your notes at paragraph 4 of my learned friend's skeleton argument, and also at paragraphs 13 to 16 of a witness statement that's in the supplementary bundle, tab 5, page 16, just for your notes.
Can we, while we're on page 109, the Beth Din of the Union of Orthodox Hebrew Congregations, does that have any published arbitration rules?
Not that we have been able to identify,
Right.
my lord.
Okay, thank you very much.
On 11th of December 2019, the parties took their dispute to the Beth Din in accordance with clause 22.2 of the SPA. The Beth Din provided the parties at that stage with a further document to sign. That document appears at tab 14 of the core bundle, page 111. This is the last page of the core bundle. I'm going to come back to this document, my lords, but if I can just show it to you now. The key parts of this agreement, about halfway down, it says, and this deed will be valid according to the Arbitration Act, which is valid according to the laws of the government. 2 or 3 lines further on, it says, the above mentioned Beth Din have the authority to issue interim judgments as they see fit, and to amend and add to and change the judgment they have given at any time. And 1 line later, this arbitration agreement is valid for an unlimited time.
Can I just ask a tiny point? It says here Beth Din rather than Beth Din. Is that the same?
Yes, it's just to do with how the Hebrew letter is transliterated into English.
Thank you. And do you characterise this as a sort of ad hoc arbitration agreement, or just recording the reference?
I think the best way to look at it, my lord, is this is the Beth Din's terms. So there are no publicly available terms. There are no generally applicable terms of the kind you might find in a commercial arbitral institution might have. This document was prepared by the Beth Din, not by the parties, but the parties signed it. So it's an ad hoc arbitration on these terms.
No evidence as to whether this is the one that the Beth Din usually use if there are arbitration agreements between members of their congregation. We just don't know if it was for this one only, or whether it's one that's a template one for all disputes that the Beth Din deal with. We just don't have any evidence.
Do you have any evidence on that, my lord? No.
Can I ask you, we have an arbitration agreement at 110, which expressly provides for arbitration by the Beth Din. Then the parties go to the Beth Din pursuant to that provision. Isn't this therefore the reference?
Yes, my lord. Perhaps it is. I'm not sure it makes a material difference to the...
Well, I think it may, because if this is a subsequent replacement arbitration agreement which supersedes the agreement in 22.2, then we have to construe this as the stand-alone agreement between the parties, don't we?
Yes.
Whereas if it's the reference, it's a reference which is giving effect to the arbitration agreement in 22.2.
Yes, and it's exactly that, my lord. In my submission, yes, the parties have gone to the Beth Din in accordance with clause 22.2, and this is the reference.
This is their agreement to refer pursuant to the arbitration.
Yes.
And it seems to me it's important in a number of respects, including that 22.2 expressly states that any dispute or claim shall be finally resolved and may be entered in a court having jurisdiction.
Yes, my lord.
So both of those are important in construing page 111.
Yes, absolutely, my lord. And page 111 doesn't cut across that in the sense that it also refers to this document, whatever it is, being valid according to the Arbitration Act.
But you do say it cuts across, because you say that the words amend, add to, change at any time is inconsistent and possibly repugnant with the underlying arbitration agreement.
Yes. When I say it doesn't cut across, this reference was clearly intended to be pursuant to the original arbitration agreement, and I'll come to repugnancy later in my submissions, but it was clear that the parties intended that their arbitration would be, according to the action, would produce awards which were enforceable using the procedure in.
This is how they were finally to resolve the dispute that had arisen between them
Yes,
and get an enforceable order in the courts.
precisely, my lord, yes.
Enforceable or potentially challengeable.
Yes, indeed, my lord.
And can I, just while we're on this, looking at the reference or further agreement, however it is to be characterised, look at the last sentence, because this says that it's all to be done in full, in the beneficial way, according to Jewish law, according to the laws of the country, i.e. England and Wales. As a form of deed, this deed will not be invalidated, neither with a deficiency, nor with an excess, nor with an erasure or blurring, and everything is upheld and valid. How you can deal with when you come to repugnancy, how do we fit that sentence with your sort of suggestion that we should, as it were, blue pencil parts of the clause?
My lord, the parties did intend this document to be binding in full. I quite accept that. But they also intended their disputes to be submitted to binding arbitration within the Act. And if the position is that those things cannot both be true, if effect is given to every part of this, and in particular to the power to change the award, that would render the dispute resolution process the parties have agreed on not in arbitration, not within the Act, not subject to the protections of the Act, and not capable of producing awards that are enforceable under the Act. Then we're in a situation where it's necessary to choose, essentially, between those two agreements. And in my submission, the agreement to arbitrate, this is an agreement to arbitrate, and that's fundamental to the agreement.
It's a translation, and obviously I don't have a Hebrew, but could you read, but I'm always doing this and it's wrong, could you read the last 3 lines? And this deed will not be invalidated, neither the deficiency nor with an excess, nor with an erasure or blurring, and everything's upheld and valid. That sounds as if you can't strike any bit out. But I wonder whether you could say you can strike a bit out, but even if you do, that doesn't invalidate it. So one wrong bit doesn't upset the whole apple cart.
Yes, my lord, and my primary submission is that this document is not invalid as a whole, because the dispute was referred by this agreement to arbitration. The arbitration took place and an award has been produced. It is only the amendment.
Yeah. So you could say this deed will not be invalidated because of any erasure or blurring, but when it says that everything is upheld, what does it mean by everything is upheld? What thing is everything?
Presumably, my lord, everything within the agreement.
Or is it everything that is done under the agreement as opposed to the agreement itself? I'm just wondering what it means.
This is a translation, my lord, and perhaps not of the most professionally drafted.
It's an agreed translation,
Yes,
and
it's
it
an
was
agreed
put before the courts.
Yes.
And what I mean, there are many advantages in sometimes having interpreters and all the rest of it there, but we're stuck with this wording
Yes.
as being the accurate agreed translation.
Yes.
Yeah.
Well, as I understand it, nobody has suggested, other than that this is to be interpreted according to English law of contracts.
Yes, my understanding is that that's common ground, my lord.
So in that situation, the job of the court is to construe the agreement as a whole in its context.
Yeah.
And whatever the result of that process of interpretation or construction is the meaning of the document. So if you undertake that process, even if it involves in the end, even if it results in the end to finding that one part of the agreement is repugnant, that is the meaning of the agreement.
Yes.
And so you're not saying that any part of it is repugnant, it is invalid, it's all valid, but it is properly construed in a particular way.
Yes.
So that's your case.
Yes, that is my case. My Lords, hearings then took place before the Beth Din in July 2020, January and February 2022 and September 2023. And for your notes, those dates are set out at paragraphs 9 to 10 of the judgment below. On the 25th of March 2024, the Beth Din made its first award. It's not necessary for present purposes to go to that, but it's in the supplementary bundle, tab 1, page 2. By that award, the Beth Din decided that the respondents were entitled to a reduction in the amount of the remaining deferred payments under the share purchase agreement, but that the amount of the reduction will need to be decided at a further quantum hearing. That quantum hearing took place in February 2024. Following that hearing, the Beth Din sent its final award to the parties by email on the 29th of May 2024, and the parties have referred to that document as the second award.
You say an email final award. Have you added the word final, or was final used in the email?
It wasn't used in the email. The email, I'm afraid, is not in the bundle, but it was before the judge at first instance. It just says PASAC attached, which means decision attached.
Right, so you've added the word final, that's the whole point thing, yeah.
Yes.
You say that it was agreed, it's common ground between the parties that it was the final.
So, my lord, at first instance, perhaps I can show you what the judge said in this regard, because what the judge found is consistent with what was the party's agreed position. The judge's part of the judgment I'm referring to is at paragraph 47, so core bundle tab 5, page 49. Paragraph 47. About halfway through that, the learned judge found, if there had been no challenge to the second award, it would have been, as it appeared on its face to be, a final award, and would have been enforceable on its own terms and under section 66. So, my position is, and this is what I had understood was common ground before the judge, was that when the award was made, it was intended to be the final award. But of course, there was later, a week later, an email saying it was under review, and my learned friend's submission is that at that point, it was no longer final, it was under review.
So do we have the email that says that it's under review?
Yes, that is in the bundle. That is at,
I think supplementary, is it? Or
yes, supplementary bundle tab 3, my lord. Yes, page 7.
So this is 7 days later, as you point out,
Yes,
and it says he's reviewing some figures.
yes. So, my
Well, he's
lord,
doing two things. He's reviewing some figures, which is to do with recalculating the award that has been set. He's also saying there's something that wasn't dealt with in the earlier award, and there will have to be a ruling on that point. So there seems to be two things at issue at the moment.
yes, my lord.
So this is within the time limits for any challenge
Yes,
to the Arbitration Act. Because, I mean, I think the effect of your submissions is no one would have drafted this agreement as it's been drafted. Fine, we are where we are and we'll have to do our best. But that the ability to change a final award is repugnant to the finality required by the Arbitration Act. And actually, if they had any complaints and wanted any changes, they should have applied to the commercial court, even though the arbitrators had written and said within 7 days, don't worry, we're sorting things out.
my lord, that's not quite my submission.
Sorry?
We accept that on the appellant's case, the result of this clause about an unlimited power of amendment is that however you get there, and I'll come on to the possible routes, the default provisions of section 57 are part of the arbitration agreement, because there's no contrary valid party agreement within section 57(1). So the default regime applies. If the default regime applies, the Beth Din was able to make corrections to its award within 28 days. There's also a question as to whether or not it would have been able to make an additional award within 56 days. The learned judge didn't address that in his judgment, and it hasn't been part of my learned friend's case. But we've looked at the 11th of December 2019 agreement. That creates the power to add to or amend or change the judgment that Beth Din has given. It doesn't say anything about additional awards, so it may be that the parties didn't intend for the Beth Din to have that power.
But add to could mean a number of things. One thing it might mean is add to, if there's something that's been left undetermined, deliberately or by accident, and they're dealing with that later, then that might be adding to it, not changing it, but dealing with an outstanding point. And that's why I wondered whether the overpayment of tax point, which I don't know the details of, was something that was an addition, not a correction, in that sense.
It could have been, my lord, yes. In any event, it would, by the time the order enforcing the award was made, if the appellant is correct that there must be a deadline and those deadlines must be the default deadlines, any additional award was hopelessly out of time by the time the enforcement order was made. So, if we are within the default regime, under precisely which of the default powers under section 57 this email could have been sent, was sent, doesn't in my submission matter, because whichever power the Beth Din was trying to exercise, it is now hopelessly out of time to do so, and was hopelessly out of time when the enforcement order was made.
That's if you follow through your construction all the way, and stick with the time limits at a time when the other party had been told that nothing was happening, or was that the matter was being reviewed.
Yes, my lord. So to be clear, what happened was that this email was sent to my client.
Yeah, to the appellant. Yeah.
Yes, copied to Mrs. Endzweig, who is the first respondent's wife.
Yeah.
Nothing turns on this for present purposes, but to provide your lordships with the context for this email, it's common ground that it followed 2 unilateral phone calls between Mrs. Endzweig and the arbitrators, which took place after the second award had been sent to the parties. Those phone calls are addressed in the judgment at paragraph 15, page 40 of the core bundle, and in my learned friend's skeleton argument at paragraph 10.
Yes, well, you say they shouldn't have done ex-party communications, and he points out that you've also done it. Is that normal practice in the Beth Din?
There's no evidence on what is normal practice, my lord. The point I make in that respect, the appellant did send several emails to the Beth Din after receiving this 6th of June email asking for updates. They aren't in the bundle, but they're summarised at paragraphs 20 to 23 of the judgment, beginning at core bundle tab 5, page 41. The appellant didn't receive a substantive response to any of those emails, and several of the emails received no response at all, whereas the respondents did receive substantive communications from the Beth Din during this period. That was where matters stood, my lord, on the 21st of October 2024, when the appellant applied to enforce the second award. That application notice is in the supplemental bundle at tab 4, page 8.
Yeah.
It is dated the 21st of October 2024. On the second page, page 9 of the bundle, your lordships will see that it is an application to enforce the award dated 28th of May under section 66 of the Act. That application, my lords, was granted on the papers by His Honour Judge Pelling KC on the 8th of November 2024. That order is at tab 6 of the supplementary bundle, page 22. Paragraph 1 grants the appellant permission to enforce the award, and paragraph 2 provides the judgment to be entered in the amount of the award. And
This is an ex parte application, and the order is made ex parte, was it?
Yes, my lord.
And there was was there any reference to the email about the errors being corrected?
My lord, it was included in the exhibit to the witness statement served with the application, but it wasn't specifically referred to. And when the respondents applied to set aside the order, they did so on two grounds. Those are summarised at paragraph 33 of the judgment. But first, they did argue that the appellant solicitor had breached his duty of full and frank disclosure in the witness statement because he hadn't specifically highlighted that email. The learned judge found that there had been a breach of that duty, but he held that he would not have set the enforcement order aside on that basis. And for your notes, that is at paragraph 39 of the judgment, page 46 of the core bundle. And there is no cross appeal on that point, my lords. And it doesn't therefore rise further before your lordships. The second basis on which the respondents applied to set aside the enforcement order was that the second award was not final, because the Beth Din had said that it was reviewing the award and had not told the parties that it had concluded that review. The learned judge accepted the respondents' submissions on that point and set aside the enforcement order. I'm going to show your lordships the relevant findings within the judgment shortly. Before I do that, I'm going to show your lordships one final piece of paper. In February 2025, the Beth Din sent the parties a further award. That is in the supplementary bundle at tab 11, page 54. This, my lords, was the product of the Beth Din's review of the second award. It is dated the 11th of February. It was in fact provided to the parties on the 10th of February. As your lordships will see, under the heading Court's Final Ruling, by this award, the Beth Din purported to deduct £200,000 from the amount payable to the appellant under the second award. There is then a very short reasoning section, which finishes at the top of the next page. My lords, this document was sent to the parties 8 months after the second award had been handed down, and 11 days before the hearing of the respondents' set-aside application before the learned judge. I'm showing it to your lordships to complete the picture, but in my submission, this document was of no effect. The Beth Din had no jurisdiction to make an amended award because it had decided the dispute by the second award, and any corrected award or additional award was by this point very significantly out of time for the reasons I'll come to.
And presumably the respondent is right, the word final is misleading because it can't be final, because you could go back and say, excuse me, you were right the first time.
Precisely, my lord.
Can I just ask, wherever it's convenient to address in your submissions, sometimes courts make final orders. For example, the Court of Appeal Civil Division can refuse you permission to appeal on the papers, and you can ask for a reconsideration, and because it's final, there's procedure under 5230 for us to do that. But if a court or a tribunal in this situation has actually said, we are reviewing it, does that in some way, because they were silly enough to send out the award 7 days earlier without saying, and we will consider any further applications, that deprives them of jurisdiction fully and finally under your submissions?
Yes, my lord, it does. It's necessary to identify the point at which an award or a judgment becomes final. In the general rule in arbitration is that the award is final when it's made. That's not to say the tribunal can't circulate a draft award, but there would need to be agreement between the parties for that to happen, because arbitration is a consensual procedure. And a draft award, my lord, it is obviously not an award which is made within the meaning of the Act. By the draft, if it's flagged as a draft and there's an agreed procedure for there to be a draft, it's not an award, it's just a draft document. In this case, I think it is common ground that the award was made on the 29th of May, when it was was sent to the parties. In what the learned judge found, and what my learned friend says, is that even though the award had been made, it could be changed. And returning to your lordship's analogy of the powers the court has, it would be very remarkable if a judge, having made a judgment, once the order has been sealed, could change his or her mind on the matters decided, and could do so at any time. If a judge in that situation has perhaps got something wrong, the appropriate route is an appeal to your lordship or to another appellate court.
Well, we have the slip rule.
Yes,
If there's a simple error, or as you say, there's an appeal. What we can't do is, in that situation, reopen it because you're functus.
yes,
Here, though, on the 6th of June, it was open to the Beth Din to correct, even on your case, because they are within 28 days. So the email of the 6th of June is entirely consistent with your case.
yes,
What you say is what they can't do is wait 8 months and then say, here you are.
yes, my lord.
And that's what went wrong here. It's not that they undertook, well, there's a question about the extent to which they could correct. But in terms of timing and in terms of saying it was under review, you don't see any problem with them saying that on the 6th of June. It's simply that they then didn't do it.
Yes, my lord, that's exactly right. The award had been made, and in my submission at least, we were then within the territory of section 57, and there is a power to correct the award, or perhaps in this case make an additional award, but that needs to be exercised by a deadline. And in the absence of any party agreed deadline, I'll come on to this, and my ground one, my submission is the default deadlines must apply, and it's vitally important that for the finality of awards, the whole scheme of the Act, that there is some cut-off point beyond which the parties know what their rights are, and they can enforce the award, challenge it in court, or whatever it may be.
Well, you presumably would say that what happened in this case is absolutely a prime example of why that must be the case.
Yes.
And indeed why going forward the Beth Din should not adopt this procedure.
Precisely, my lord.
We've used the words award and final award, but those are labels. I just wonder if it wouldn't be helpful to look at the supplementary bundle tab 2 and then at tab 11 to see what the Mishpot did. It
Yes.
describes the dispute. The heading is court's ruling, and it says, after listening to both parties and analysing their arguments, we reached the following conclusion. Party B is to pay that amount of money to Party A. And we know what that relates to because we've seen the preamble and we can work it out from the reasonings. So that was a conclusion as to who should pay who, what amount for the purchase price. And then when you go to tab 11, again is the reference to the dispute between them, and it says court's final ruling this time. They've added the word final. And it says, following on from the ruling and after analysing the counter-arguments and after analysing all the accounts, we reached the following conclusion. And that's a different conclusion from the previous conclusion.
Yes.
I don't know whether it's properly described as a correction or not, but that's what they did. So there was a conclusion on who owed what to whom, and then there was another document containing a different conclusion on who owed what to whom. And the question is whether they can do that, I suppose.
Yes, my lord. That's exactly right. And in my submission,
They can't.
they can't.
Because you say the conclusion, however it's described, was the final resolution of the arbitral dispute about who owed what to whom.
Yes,
Yeah.
my lord.
Not sure that that helps, but it's analytically correct.
If I can turn then to my second topic, my lord, being the key provisions of the Arbitration Act. I'm going to show your lordships 5 provisions of the Act. The first key provision is in the Authorities Bundle, tab 16. page 332. This is section 1, and I'm sure you'll have seen many times, so I'm not familiar with it. This sets out the principles underlying the Act, in accordance with which the other provisions that we're going to come to must be construed. Principles A and B are particularly important in my submission to this appeal. They are that the object of arbitration is to obtain fair resolution of disputes by an impartial tribunal without unnecessary delay or expense, and B, that the parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. And I would invite your lordships to have those principles in mind while looking at the other provisions I'm going to turn up. The second key provision is section 57, which is at tab 24 of the authorities bundle, page 350. Paragraph 1 provides the parties are free to agree on the powers of the tribunal to correct an award or to make an additional award. Paragraph 2 then provides the provisions which will apply if or to the extent there is no such party agreement. And paragraph 3 sets out the scope of the default power of correction, that's subparagraph A, and the power to make an additional award, that's subparagraph B. The default power of correction allows the tribunal to make slip rule type corrections, and the default power to make an additional award is in relation to claims which were presented to the tribunal but which were not dealt with in the original award. And paragraphs 4 to 6 provide the default deadlines, which are 28 days for corrections and 56 days for any additional award. I'm going to come back to section 57, but for now I'm just showing it to your lordships. The third key provision is section 58 of the Act, which is at tab 25 of the authorities bundle, page 352.
Sorry, 352. Yeah.
352.
Yeah.
Section 58 of the Act.
Yeah.
This provides that unless otherwise agreed by the parties, an award made by the tribunal pursuant to an arbitration agreement is final and binding on both the parties and any other persons claiming through them. This does not affect the right of a person to challenge the award by any available arbitral process of appeal or review, or in accordance with the provisions of this part.
So does that mean you can have an agreement where you agree an arbitration agreement? And I appreciate we've got the SPA, which does say final. Shouldn't be final and binding.
No, my lord, and that's common ground. My learned friend accepts that paragraph 32 of this skeleton argument, and I won't ask your lordships to turn to it as it is common ground.
Well, and that seems orthodox, but it's 57.1 doesn't suggest that you might be able to, because unless otherwise agreed.
Yes, people have made that argument, my lord, but it has been dismissed
Rejected.
every time. And if your lordships would like for your note, there's some commentary on that point in the authorities bundle, tab 35, page 462. That's Muscle and Boyd on commercial arbitration at paragraph 1.5. I don't think we need to go through it.
I mean, it's the orthodox position, but it's just a very odd provision.
Yes.
Yeah.
The question which arises then is obviously what is meant by unless otherwise agreed by the parties. There are, my lords, 3 different possibilities in terms of who can review an award once it has been made. The tribunal which made it, an appellate tribunal, or the court. Applications to court are dealt with by sections 67 to 69 of the Act. They're in the bundle starting at tab 26, but we don't need to turn them up. Section 58 also allows the parties to agree an arbitral process of appeal or review. That's referred to in section 58, paragraph 2. The established view of both first instance judges and the leading commentators, my lords, is that this means a process of appeal to or a review by an appellate tribunal, not to the tribunal which made the award.
You say established view, that's a very interesting choice of words. You don't say it's binding on us.
No, it's not binding on
It's not
you.
binding, so
my
we've got to
lords.
decide, we might have to decide.
Yes, we
whether
might
that's
have to
correct.
decide the
Okay.
point. That there is no, neither party has identified any appellate authority dealing with this point. But I will come on to what the lower courts have decided and what the commentators have said. Before I do that, and because it's relevant to what they say, I want to show you two more provisions. The first is the definition of arbitral process of appeal or review, which the Act provides. That's at section 82 of the Act, Authorities Bundle, tab 30, page 367. This is the fourth of the 5 provisions I wanted to show your lordships. It's the second definition, available arbitral process. In relation to any matter includes any process of appeal to or review by an arbitral or other institution or person vested by the parties with powers in relation to that matter. You might say that doesn't move things much further on, my lords, but I'll come back to what has been said about that in the cases and the commentary. The fifth provision I want to look at is section 70 of the Act, which is the previous tab, tab 29, page 363.
Sorry, which page was that?
363, my lord.
Thank you.
Section 70. This concerns the circumstances in which the court will hear a challenge to or an appeal from an arbitral award. Paragraph 2 provides that a challenge or appeal may not be brought if the appellant, the applicant has not first exhausted any available arbitral process of appeal or review and any available recourse under section 57, brackets, correctional award or additional award. I'm showing your lordships this now because previous judicial consideration of the relationship between arbitral process of appeal or review and section 57 has generally arisen in the context of applications to challenge an award in court and therefore under this section. But available arbitral process of appeal or review is a defined term in the Act, and I think it's common ground, it must mean the same thing wherever it appears. My lords, in my submission, the position is summarised in the current edition of Mustel and Boyd at Authorities Bundle, tab 35, page 480. At paragraph 14.170, the editors address what is meant by a process of appeal or review in section 70 of the Act. And they state that any available arbitral process of appeal or review is a process by which an award is subject to appeal or review by another arbitral body, not the same body that made the award. That statement is made by reference to 2 first instance decisions. As I said, my lords, there is no appellate authority on this point, but I will show your lordships the reasoning of the lower courts, which may be helpful in identifying the principles. The earliest of the 2 decisions cited in Mustel and Boyd is a decision of Mr. Justice Tier in a case called K&S from 2015. The law report for that case appears at tab 8 of the Authorities Bundle, page 134. My lords, in this case, the court was considering whether a correction by the tribunal of its own award under section 57 of the Act amounted to an arbitral process of appeal or review. And that was relevant because if it did count as an arbitral process of appeal or review, that would have extended the deadline for a jurisdictional challenge to the award under section 67 of the Act. The key paragraph, my lords, is paragraph 18, which is on page 138. If I can read that out. I accept that in one sense, a correction of an award involves a review of the award, because it is only by reviewing it that the tribunal can decide whether there is a mistake, error, or ambiguity which needs to be corrected. However, in my judgment, it is clear from section 72 of the Arbitration Act that an arbitral process of appeal or review is different from any available recourse under section 57. I consider that the former process is one by which an award is subject to an appeal or review by another tribunal, and 2 examples are provided of that type of structure, whilst the latter recourse for correction is to the same arbitral tribunal which issued the award. This distinction is consistent with the definition of available arbitral process in section 82 of the Act, and was also drawn out by Mr. Justice Edward Smith in a case called Price and Carter. I respectfully disagree with the observation of Mr. Justice Jackson in a case called Surefire Systems, if he was referring to a correction pursuant to section 57 of the Act.
What if it's pursuant to the terms of the agreement itself? Though I can understand if you're contrasting the section 57(1) exercise with section 70, but if it's something under the agreement itself, assuming they can go back and do it under the agreement itself, why then should that not be an arbitral process of review?
Because, my lord, if it's right that an arbitral process of appeal or review always refers to appeal or review to another tribunal.
But only, you say, because section 57 implies that. But if you're not in section 57, that doesn't indicate that the answer for a non-section 57 process of arbitral review has to be to another body.
Fundamentally, my lord, is for public policy reasons, the same public policy reasons that mean that a judge, having made a final decision, can't change his or her mind. Arbitration is a quasi-judicial process which is intended to finally resolve disputes. And it would be very surprising. I accept that section 57 and section 58 do not make this point particularly clear, and that is why there have been arguments about it in the lower courts. But in my submission, section 57 creates a power of slip rule type corrections, very similar to the powers that a judge has to correct an order or award. There is also the power to make an additional award. That arises, at least under the default rules, where the tribunal hasn't decided an issue that was before it. So in relation to that issue, the tribunal is not functus officio.
The other way of looking at it is, if when you're dealing with the default power under section 57, the Act presupposes there's a difference between an exercise by a tribunal of its default power, and that isn't an arbitral process of appeal or review. By analogy, it wouldn't have expected something that was an agreed arbitral internal process to be an arbitral process of review. That you interpret the Act as assuming that it covers both the section 57 powers or any akin powers permitted by section 57(1).
Yes.
That's one way of looking at
Yes,
it. Yeah.
my lord.
Sorry, I haven't put that clearly. I don't think you can see what I'm saying, I think. Yeah. Anyway, sorry. Yeah.
My lord, the doctrine of functus officio is ultimately what is underlying for all my submissions. If it's right that once the tribunal has made its award, it is then functus. Section 57, it cannot change its award unless there is some power that allows it to do so. Section 57 is one of those powers. It's the only, in my submission, statutory carve-out to the position that once an award has been made, it is final. The tribunal can't change it. And anything that goes beyond the bounds of section 57 encroaches on the doctrine of functus officio. Before I move on from K&S, my lords, I should just flag that the issue of the appropriate deadline for a challenge to the awarding court, which is what Mr. Justice Tier was deciding, where there have been corrections under Section 57, no longer arises because the position has now been clarified by the Arbitration Act 2025, which amended Section 70 to reflect what Mr. Justice Tier decided in this case, that essentially depends on the materiality of the changes. We don't need to go to those amendments, but for your Lordship's notes, they're at paragraph 3A of Section 70, page 363 of the Authorities Bundle. The second decision, cited in Muston and Lloyd on this point, is a decision of Mr. Justice Bryan in a case called Daewoo Shipbuilding from 2018. The law report for that case is in the Authorities Bundle at tab 12, page 173. The issue in this case was the same as that in K&S, my lords. The court was determining the deadline for a challenge to an awarding court in circumstances in which the award had been corrected under Section 57. Mr. Justice Bryan considered the issue afresh and reached the same conclusion as Mr. Justice Tier. For your Lordship's notes, the learned judge provided a very thorough review of the authorities at paragraphs 27 to 46 of the judgment. That begins at page 181 of the Authorities Bundle. His conclusion is at paragraph 53, page 191. He says, as to the meaning of any available arbitral process of appeal or review in Section 70, I share the view of Mr. Justice Tier and K&S that this is a reference to a process by which an award is subject to an appeal or review by another tribunal. An application to the same tribunal for a correction of the award does not fall within the ordinary and natural meaning of such language. On the contrary, I consider the ordinary and natural meaning of such language in the context of a statutory provision that draws a delineation between an appeal or review and a correction is that it is a reference to a process by which an award is subject to an appeal or review by another arbitral body. That is supported by the fact that, under Section 57, and absent any contractual provision permitting it to do so, and I'll come back to that, a tribunal cannot reconsider whether it reached the correct decision or indeed change its decision, given that it has already delivered its award. Rather, any recourse is by an appeal or review by another arbitral body, or absent that, under Section 69 of the Act. My lords, in my submission that is correct, except for the suggestion in the final sentence that a first instance tribunal could be empowered by a contractual provision to change its decision. My lords, on that, the scope of the agreements that the parties could make within Section 57(1) was not an issue in the Daewoo case, and Mr. Justice Bryan was not referred to any authorities on that point. So I'll come back to this issue when I make my submissions on the second ground of appeal, but I just want to flag that part of the paragraph.
So you say that that was a sort of just misspoken in error, as it were?
Yes, my lord, Mr. Justice Bryan hadn't considered that issue. It wasn't an issue on the facts of this case, and perhaps assumes the parties might be able to.
Well, what about if the arbitration clause contained a provision saying you can come back with any errors, if you identify any errors or omissions within a period of 28 days, and thereafter we'll determine it within 56 days. That would be consistent with what Mr. Justice Bryan said.
Yes.
So, in fact, it just depends which contractual provision you're talking about.
Yes, my lord, in my submission, a provision of the kind you've just described is a sort of agreement the parties would be able to make within Section 57(1) because it's a power to correct, and I'll come to what that means, but essentially a power of correction involves correcting how the decision was expressed, but not changing the substance of that decision. That is not a correction. And an omission maybe a correction of that type if it's just something minor that was left out. If it's a whole issue that wasn't decided by the tribunal, again, the tribunal is not functus as regards that issue, and it's possible to make an additional award. In my submission, the parties cannot agree that the tribunal can change its mind on an issue going to the heart of what was decided. That's not to say there can't be a draft award process. If, for example, there was a provision which said the tribunal can change its mind on this decision within 2 weeks, the court would have to decide how to construe that. It may be that on the facts of a particular case, it could be construed as allowing there to be a draft award, which is not a final award, not an award which has been made, and the tribunal will then hear further submissions on the draft and make a final decision. That wouldn't be problematic. But in my submission, the parties to a valid arbitration agreement cannot confer on the tribunal a power to genuinely change their minds, having made a final award.
So if, just when I get to the calculation of award or point, I multiply something when I should have divided by it, and both parties write in afterwards, that's actually changing the substance because it's going to reduce the amount payable. You say that would be inconsistent with?
No, my lord. In my submission, that's not changing the substance. In a particular case, there may be difficulties determining what is a correction and what is the substance of the decision.
Yeah.
And your lordships don't need to grapple with that today in the sense that we are not here discussing whether or not the final award, had it been made in time, was made changes of the kind the tribunal was able to make.
When you say the final award, do you mean the third one?
Sorry, I mean the
third one.
Oh, so, a slip of the tongue.
Yeah.
My lord's example, if the tribunal made a conscious decision that they should divide rather than multiply, that would be correct. That wouldn't be correction. That would be to change their decision. But if they just simply put a division sign rather than the time sign, that would just be a correction in the slip rule.
Precisely,
Yeah.
precisely, my lords. The issue is to determine what did the tribunal decide substantively on these issues. What did it decide was the right outcome? It may be that the tribunal has made a very material error in how that decision has been recorded. They've put the wrong number, they've divided when they meant to multiply, whatever it is. And there may be an argument on an application for a correction in those circumstances about, whether or not that was really a slip or whether or not it went to the tribunal's reasoning. It's not always an easy distinction, but it is a vital distinction, my lords. The tribunal cannot change its mind on an issue it has actually decided if it has made an error in how it has expressed that decision. It's similar, my lords, to recording an order. Once a judge has given a judgment, that is the judgment. The order just records what that decision was. If it records that decision horribly wrong, it can be corrected, but the judgment, the fundamental decision, can't be changed.
Changing the facts, if they heard the witnesses and they said, we just don't believe this person, and then 2 weeks later they said, well, we thought about it, we're a bit harsh, we do believe him, we would say that wouldn't be allowed.
That wouldn't be allowed.
Because that is changing it. So in this case, if they said, we've got to analyse the way in which the contract works, and it's the aggregate of the 2.5 years, not year by year, then that would be changing the basis. But if they just forgot that there was a third page of figures to calculate, or they put the decimal point in the wrong place on the calculator, that would just be correction.
Precisely.
That's it. That's the kind of distinction.
Yes.
Yeah, okay.
Thank you, my lord.
What if it's identical twins? Sorry, I'm just thinking of the examples. We don't believe him. He never said that. And then the next day, the identical twin says, no, he didn't. I did. And don't worry about it. I'm just wondering, testing your fundamental reasoning. But that's what you're saying, I think. You've got to work out what has been decided on the issue of principle, not the way in which you carry that forward into an arithmetical calculation.
Precisely.
Yeah.
It may be helpful, my lords, to consider the sort of changes that a judge to make under the same law, because arbitrators are carrying out a function if it is a valid arbitration agreement, the court will not hear the dispute in favour of the arbitral tribunal. And then again, that's an important public policy dimension to this. Section 57 is, in my submission, clearly intended to be equivalent to, parallel to the type of civil law that exists in the civil procedure rules. I'm not saying it's exactly the same, but that the principle, the functus principle, is essentially the same. The point about an arbitral tribunal, what makes it different to someone determining a mediator, for example, another form of ADR, is that the decision of the arbitrator, like the decision of the judge, finally determines the dispute. And the functus officio doctrine underlies both of those processes, both types of decisions. It's not to say there can't be difficult issues, but that's the principle, my lords.
What you correct under the slip rule is an order. So is it the case that what we're talking about here effectively is correcting the dispositive section of the order?
In this particular case, my lord,
Well, in any
generally.
case.
No, but my lord, in my submission, the tribunal can, under section 57, make any change to the award, which is a correction within the meaning given in section 3A to any part of the award. That's what section 57 3A says.
But what you're doing is making sure that the document reflects
The
what was
decision.
decided, because there's been some errors which needs to be corrected.
Yes.
If you look at page 54, it's always helpful. I know you don't want to look at the details of tab 11 of the supplementary bundle. You can see what they did here, because it says following on from the ruling that we issued, and after analysing the counter arguments, so those seem to be arguments about how you construe the clause, and then after analysing all the accounts, we reach the following conclusion. So that doesn't sound like we pressed the wrong button on the calculator. That sounds like we've listened to the arguments again, and having listened to the arguments, we've gone back over the figures, and what we now think is it should be 200,000, not 300,000. Not that we put the wrong figures in, but we've changed the reasons why we think it should be a particular sum.
Yes, my lord.
And that you say isn't a correction.
That is not a correction.
Yeah.
But one point I would make, my lord, is that, yeah, I do very much say that the changes that were made by this third award were not corrections. But in a sense, that's not really relevant to today's appeal. The issue is to understand an enforcement order was made before the third award materialised. So the real issue is whether at the point that the enforcement order was made, what jurisdiction, if any, did the Beth Din have to change its award? The reason why I'm addressing your lordships on the type of corrections that are theoretically possible is because that goes, the question is, was the Beth Din's jurisdiction to make changes contained in the default provisions of section 57, or was it a power to add to or amend or change at any time, as it says in that December 2019 agreement? So the first question is, was that agreement about changes at any time one that the parties were able to make? I say there are two reasons why it wasn't, and those are the two grounds of appeal. The first is it's completely untime limited, and so will mean the dispute is never finally determined. There can always be more changes. And second, because the parties cannot confer on the tribunal a completely unlimited power to change their award. Whether or not the third award, how wide-ranging the changes actually were, is really immaterial. The point is, was that agreement valid? Because if it was, then that's where the Beth Din's jurisdiction to make changes derives from. But if it wasn't, then the Beth Din's jurisdiction, there is no alternative party agreement because no valid party agreement, and the jurisdiction is in section 57(3) in the default rules. And if that's right, it's common ground, and the judge found that by the time the enforcement order was made, the second award was final. There could be no further changes.
Can I just try one point, because I mean I think we all agree that this is suboptimal drafting and trying to do our best with it. Just section 57(1), which actually expressly refers to the fact that the parties are free to agree on the powers of the tribunal to correct an award or make an additional award. And that's obviously what the Beth Din probably thought they were doing, but as you rightly point out, you've still got to have finality in an arbitration award. But if we're trying to give effect to what they've done, what is wrong with saying, okay, the error that the Beth Din did was not making this, as it were, time limited, because as you rightly point out, you can then change it in 20 years' time, and how can you enforce awards and that? So they purport to make this freestanding agreement, but they didn't time limit it. But then you read in, as it were, application for the exercise of those powers within 28 days of the award, and then you go back to one with what you say is otherwise objectionable, because you can always amend. And then what has actually happened is you've taken out the 56-day limit, which is obviously what the rabbis thought, that they weren't restricted to 56 days. You've given effect to the parties' agreement, which we're told as courts we should try to, but obviously there are limits, and it is putting in the default provision of making it within 28 days. And actually, as it happened, it was within 7 days in this particular case. So it's different reasoning, as it were, from His Honour Judge Keyser, who I don't think necessarily grappled with parts of your point, but at the same time gives effect to what the parties were trying to do, which was to give them powers beyond just mere slips and corrections, but it had to have a time limit. What would you say about that proposition?
2 points.
Yeah, of course.
My lord. First, on the timing point, the fact that the Beth Din said within 7 days or whatever it was that it was reviewing the award does not satisfy the time limit point. What section 57 requires is that the changes themselves are made by 28 days for corrections or an additional award within 56 days. It is no help, my lord.
Well, unless otherwise agreed.
Yes, my lord, but in my submission it's necessary for there to be finality. That requires a deadline. The Beth Din, having sent an email saying it was reviewing the award, does not give finality, because the Beth Din could have taken 8 months, as it in fact did, to produce an amended award. It could have taken 7 years. It could still have not produced the award. My client, the appellant, could have enforced the award for a new award to then land at any time later. Likewise, if all that is required is for the Beth Din to say it is conducting a review by some deadline, again, the award is still not final, because my clients could...
Well, absolutely, but then you have different remedies. The courts are well used to dealing with arbitrators that don't get on with things, and they can, in certain circumstances, be removed or directed to do things. It's just we're talking about the jurisdiction to make any award. I know your point is that once the final award was given, then that was it, subject to 57 as default rules.
My lord, in my submission, it is necessary for there to be a clear, finite deadline that the parties know in advance by which time the award will be final. And it requires that any amended award, whatever the changes that are made, must be provided by some deadline. The parties could have agreed that the Beth Din could correct its award within 2 years, and that would lead to a very slow arbitration, but it wouldn't be contrary to Section 58 of the Act and the finality of awards, because the parties would know when the award crystallised into something that was final and enforceable. In a situation where the Beth Din have sent an email within 28 days saying we are reviewing this, but have then not produced an amended award for 8 months, there is no finality, because there is no long stop date for the Beth Din to produce its award. And that's important. It's evident from the default regime, which provides 5, any correction must be made within 28 days of the date the application was received, or where the correction is made by the tribunal on its own initiative within 28 days of the date of the award. So that deals with both these points in the chronology. There's a point when there is a request for a reward, for an amended award, and then a point by which that must have been provided. And that long stop date, there can be no finality unless there is a long stop date. On the type of changes that the parties are able to agree, my lord, in my submission it is correct, it must be correct, that a power to an arbitral process of appeal or review means by another tribunal. It is contrary to the doctrine of functus officio for a tribunal, having made an award, to change its mind, unless it can be established that the original award was a draft, and that will be a construction of the parties' agreement in the particular case. But it's not what happened here. Unless that can be established, once the decision is made, it's made. That is the nature of exercising a judicial function. And if that's right, then the parties can agree, whatever deadline they so wish, as long as that is a deadline, for corrections to the award or an additional award.
I'm sorry, you're getting lots of questions. I'm sorry about this. Can I go on to a slightly different topic? I'm just working through what you say. I understand your point about time limits. This is a different topic. If you look at 57.1, it says the parties are free to agree on the powers of the tribunal to correct an award. Don't worry about additional awards at the moment. So when we get to the agreement, they were obviously trying to agree things insofar as they were allowed to agree things. And the words that we've got are change at any time, and we've got our submissions at any time. But change in the sense of substitute a different basis for different reasons for the award, can that really be a correction? And if it's not a correction, do we strike it out, or do we say that the word change, however it's translated, can only have meant the kind of change is contemplated as ones they're allowed to make under section 57.1?
Yes, my lord. So that is my primary submission on ground 2, that any power that allows the original tribunal to change its award has to fit within section 57.1. That is the space that Parliament created for agreement of those types within the Act. So the question is, does the parties' agreement in this case fit within section 57? And as your lord rightly identifies, section 57.1 only allows the tribunal to correct an award.
So we wouldn't be blue penciling out the words change. It would be interpreting the word change as to mean a change of a sort that is permitted by section 57.1, because if they were doing anything because they wanted it to be with the Arbitration Act, it must have been the sort of things that were permitted by the Arbitration Act, and that is a correction of a wholesale substitution.
Yes,
Yeah.
yes, my lord. There are multiple options. If your lordships are with me that the parties are not in fact able to make an agreement that the tribunal can make any change to the award at any time, how the relevant line of the December 2019 agreement is dealt with, there are various options, but in my submission they do lead to the default provisions in effect applying. One option is, as my lord says, to construe the December 2019 agreement to be consistent with section 57.1, and in the absence of any, the parties haven't specified any other limits, either temporal or substantive, for that power, so the limits must in those circumstances be the ones found in the default.
You've got different things. Change you can interpret to mean change of a sort that amounts to a correction.
Yes.
At any time is more of a problem, because at any time seems to mean at any time, and you've got a separate argument there that that is inconsistent with the nature of an arbitration agreement. So perhaps you can interpret some of it as pencil.
Yes.
But it's hard to see how the words at any time can mean anything other than at any other time.
No, I see that, my lord.
Yeah.
And it may also be that section 57.1 says the parties are free to agree on the powers of the tribunal to do these things. that obviously presupposes that the parties' agreement is valid in the sense that it's one that is allowed within the scheme of the Act. If they've made an agreement which is not allowed within the scheme of the Act, then there in fact is no agreement within section 57(1).
You've either got to interpret it so it is in accordance with the Act, or you've got to say, well, we tried our best, but we can't, and we blue pencil it.
Yes. My Lords, I'm now going to turn to the judgment below. This is my third topic, what the judge decided and the two grounds of appeal. My Lords will find the judgment in the core bundle at tab 5, page 37. Just to provide the context, my Lords, this judgment was delivered orally at the conclusion of the hearing before the learned judge, which had only been listed for 2 hours, and that's in contrast to the full day we have before your Lordships. The learned judge's key findings are set out at paragraphs 45 to 50 of the judgment, beginning on page 48 of the bundle.
Sorry, which page? Sorry.
48, my
Thank
Lord.
you very much indeed.
At paragraph 45, towards the bottom of the page, the learned judge found that the parties' 11th of December 2019 agreement, that the Beth Din would be able to change its award at any time, was an agreement within the scope of section 57(1) of the Act. At paragraph 46, he dismissed the appellant's submission that the result of those, pardon me, my Lords, at paragraph 46, he found that the default deadlines set out later in section 57 therefore did not apply. At paragraph 47, he dismissed the appellant's submission that the result of those two findings was that no award produced pursuant to the parties' agreement would ever be final. The key part of paragraph 47 begins 4 lines in. The learned judge held the premise that no enforceable award would ever be attainable is, in my view, simply false. If there had been no challenge to the second award, it would have been, as it appeared on its face to be, a final award, and would have been enforceable on its own terms and under section 66. If there were conduct that amounted to spoiling tactics, for example, repeated requests for a review in order to prevent an award from ever being final, a scenario I have to say that seems to me to be rather far-fetched, especially in the context of the Beth Din and more notional than a realistic guide to proper construction, the Beth Din would have ample power simply to declare itself functus officio. Fundamentally, I regard as incorrect the claimant's contention that the absence of a time limit and the provision that awards can be altered at any time entail the impossibility of finality and therefore enforcement. At paragraph 48, the learned judge further held that indefinite delays could be prevented by an application to remove the arbitrators. At paragraph 49, the learned judge held that the court should strive to give effect to what the parties had agreed. That's lines 1 to 4. He then held that the 11th of December 2019 agreement was not itself uncertain, in that it is possible to understand what the parties had agreed. That is at lines 6 to 9, the middle of paragraph 49. And finally, the learned judge reiterated that any excessive delays or uncertainty as to whether an award is final can, as a matter of practicality, be cured in one of the ways set out in paragraph 47 of the judgment, or by an application to remove the arbitrators, and that's lines 4 to 6 and 11 to 13. Having made those findings, my lords, the learned judge concluded at paragraph 50 that the second award was under review when the appellant applied to enforce it, and set the enforcement order aside. My lords, 2 grounds of appeal arise from those conclusions. your lordships would have seen them in my skeleton argument. The first is that the learned judge was wrong to find that the parties to a valid arbitration agreement can confer on the tribunal a power to amend its award that is not subject to any time limit. The second ground is that the learned judge was wrong to find that the parties to a valid arbitration agreement can confer on the tribunal a power to change its mind on matters that it has already decided. Beginning, my lords, with the first ground of appeal. This is addressed at paragraph 35 onwards of my skeleton. I have two submissions to make in this regard. The first is that an agreement that allows the tribunal to change its award at any time is incapable of producing a final award. And in my respectful submission, the learned judge was wrong to conclude otherwise. If your lordships are with me on that first submission, my second submission is that the learned judge was wrong to conclude that a term which is incapable of finally resolving the dispute can nonetheless form part of a valid arbitration agreement. Beginning with my first point, the starting point is, I think, the 11th of December agreement itself. That's in the core bundle at tab 14, page 111. My lords, what this document says is that the Beth Din has the authority to amend, add to, change the judgment they have given at any time. The document also says that the arbitration agreement is valid for an unlimited time. In my respectful submission, the starting point, as a matter of construction, and my laws of common sense, must be that at any time means at any time. If this term is to be given effect, the result must be that the Beth Din can change its award, even years after making it, whether at its own initiative or because one of the parties asked it to do so. It can also change its award multiple times. No iteration will ever be final, because the Beth Din will always retain the power to make further changes. As drafted, my lords, this document imposes no limits whatsoever in terms of when changes to the award can be made or how frequently.
It also means, doesn't it, that it's hard to see how the judge was right in saying that they could declare themselves functus.
Yes.
Because to do so would be contrary to this interpretation of their powers.
Precisely, my lord. This was going to be my... The learned judge gave 3 reasons for his conclusion that this term of the agreement did not prevent an award from becoming final. One of them, as my lord identifies, is that the Beth Din could simply declare itself functus officio. That was going to be my second point. I will deal with it as my lord has raised it. This is an important point because it features very prominently in my learned friend's skeleton argument as a reason why your lordship should dismiss the appeal. For example, at paragraph 2 of his skeleton argument, my learned friend submits that the parties' agreement should be construed so that it was for the Beth Din to declare itself functus officio. And at paragraph 53 of his skeleton, my learned friend submits that that is what the Beth Din has now done in respect of the third award. And I should clarify, my lord, that that argument arises because the Beth Din's covering email, when it attached the third award, said that any challenge to the third award had to be made within 7 days. I'm afraid that email isn't in the bundle, but my learned friend has provided an accurate summary of it at paragraph 21 of his skeleton argument.
What happened, may be completely irrelevant to this, but what happened as a matter of fact to your, I thought your client had also had a sort of ex post facto challenge to the provisional or the preliminary ruling, the first award.
I don't think so, my lord. What happened is that both parties were in fact unhappy with the
Yeah.
second award. The appellant, a rabbinic attorney acting for my client, did send a lengthy
Request for review.
request for review, yes, and that didn't receive any response. Both parties have, in this case, written to the tribunal after the second award was made, making comments on the substance of the award. I quite accept that. But, my lord, that cannot change. The fact that the parties may both have misunderstood.
I entirely accept that. I just wanted to find out, as a matter of fact, what had happened. So as far as we know, your client's rabbinical attorney's request for review went nowhere.
Yes, it went nowhere. There was no response.
No.
Do we know what happened to the overpayment of tax issue?
No, my lord, and this is slightly mysterious, as you will have seen the email saying the award was going to be reviewed. One of the points was that it was to do with an overpayment of tax. It's slightly unclear why an overpayment of tax would be an issue within the Beth Din's jurisdiction, but in any event, the third award does not make reference to that. There is a Section 68 challenge to the third award in the event that the appellant doesn't succeed before your lordships on this appeal. There will be a circuit commercial court hearing in April as to whether or not the third award, as it was later, as it in fact
Is a proper interpretation.
exactly.
But we can forget about this point about the overpayment. We don't need to worry about what is an additional as opposed to a changed, as opposed to a corrected or amended.
Yes.
Or, okay.
My lords,
Just picking up this concept of declaring yourself functus. It is a strange concept, because you're either functus or you're not.
yes,
And if you are functus, you can't declare anything.
yes, my lord, precisely.
So doesn't seem to me it works on any basis.
No,
If you're not functus, then you can't declare yourself functus because you're not. If you are functus, you can't do it because you can't do it.
yes, my lord, that's entirely right. My learned friend correctly makes the point in his skeleton that functus is not a term of art. What it means is that the tribunal has exhausted its jurisdiction to deal with a particular issue. If the Beth Din either has or has not exhausted its jurisdiction. On the appellant's case, the jurisdiction was exhausted when the second award was made, when it was intended to be a final award, subject only to a power under Section 57 to correct it. And if that's right, as my lord says, there's no scope for the Beth Din to decree anything about its own jurisdiction after that.
Just dealing with the judge's objection, one way of reading what he said, plainly, my lord is right if you're either functus or you're not, but one way of reading it is a sort of declaration that although they have the powers to amend and add and change the judgment they have at any given time, they're declaring that they won't exercise those powers in the future.
Yes, that is one way of reading it, my lord, but that's not something the Beth Din is able to do, because any power that the Beth Din may have to make post-award changes has to be one that is agreed between the parties. And what the judge found, and what my learned friend's case is that the parties agreed in this case that the Beth Din could change its award at any time.
I can change the third award, can't
Yes,
I?
yes, exactly, my lord. If the learned judge's approach to this term is right, my client retains, both parties retain the right, under the agreement, to go to the Beth Din and say, you've got it wrong again, please meet this further witness or read this further case or whatever it may be.
Read the clause again and read the
Have another
extract from
go.
the cases that you referred to and think again, because you've just got it round your neck. They wouldn't say that to the rabbi, but that would be the end result.
Yes, my lord, precisely. And the fact that the Beth Din, the starting point is what did the parties agree? And if they agreed that the Beth Din can change its award at any time, that's what they agreed, and the Beth Din cannot declare itself functus. The fact that the Beth Din has now made a third award and has said it will become binding after 7 days has no bearing on that analysis, because it's obviously necessary to look at the December 2019 agreement as it was drafted. an email sent by the Beth Din over 5 years later can't change the content of the parties' agreement.
Isn't the most direct, that's not direct, but perhaps the simplest way of looking at this question of timing is that section 51, so 57.1 provides that the parties are free to agree on the powers of the tribunal. And then it provides that if there is no such agreement, it then sets out what effectively would have to be in such an agreement, and that makes it plain that the powers of the tribunal, agreeing on the powers, must necessarily include the time in which they can do it.
Yes.
Otherwise, you haven't agreed what their power is.
Yes, my lord, I think that that's a very good way of looking at it. For there to be a power, an agreed power which fits within section 57.1, the power must be time limited.
One can note, perhaps just in passing, that even the default provision, 57.6, does make a provision for the parties to agree an extension.
Yes. Yes, my lord, and the parties absolutely are free to agree a long period, even a very long period. What is essential is that there is a...
That 4, 5 and 6 all provide that.
Yes. Yes, I don't suggest for a moment, my lord, that the parties can't agree a different deadline or a much longer deadline.
What it does suggest is that it would be bizarre if, where you have the Act provides the default provisions, which have 3 subclauses, subsections devoted to timing. If 57.1 meant the parties could agree powers but didn't make any provision for timing.
Yes, my lord, I think that's right, and you'll see that section 57.2 provides that these default provisions apply if or to the extent that there is no agreement between the parties within 57.1. So it may be that, in a sense, an agreement under section 57.1 has 2 parts. What is the scope of the substantive correction power, and what is the deadline? If the parties have agreed one half of that, but haven't addressed the other issue, then the default provision steps in. So, for example, the parties could have agreed that the tribunal can correct its award, but not said what corrections means in this context, within 10 days. The parties have then agreed a deadline, that's effective. The power of correction has to be given meaning by reference to 57.3a in that situation, because the parties haven't specified what else they intended to mean. And it has to be possible, both in terms of the time limit and in terms of the substantive power, to delineate what this power is and what falls inside it and what falls outside it.
If you're looking back at the agreement again, they could they not, agree that you can add at any time? So that's not a problem on this analysis, because add we're treating as resolving something that they haven't got round to resolving. And is there any problem in them agreeing that they can add at any time, i.e. they can take forever if they wish? It's the change at any time that's the problem.
Yes, my lord, I think there probably is. That, in my submission, that's not an issue which has arisen on these facts. There isn't necessarily... The problem is slightly different as regards an additional award. Because once an additional award... If the tribunal hasn't addressed an issue, it is not functus as regards that issue. So there's not the same encroachment on the finality of an award that's been made. In my submission, it is nonetheless necessary for there to be some deadline for an additional award, because otherwise it would be very undesirable, including from a public policy perspective, for the tribunal to be continuing to consider some part.
Surely all the same concerns arise, don't they? Because if you had an award which the claimant then went to enforce, but then the tribunal makes an award on a claim made by the defendant, which would set off against the claimant's award. It would again undermine the finality of what you're enforcing.
Not necessarily, my lord, because an additional award has to be made in relation to an issue that was not decided. So it wouldn't. The fact that the tribunal may make an additional award would not prevent the original award from being enforceable. The additional award is a separate award made by the tribunal on a different issue, which once made, the tribunal could correct, according to section 57, by those deadlines, which the claimant could challenge in court as a freestanding award within the deadlines provided for that within the Act.
When you have claims that are in relation to which there's a set-off?
Well, my lord, in that situation, there is no additional award in this case, but
Yes.
the parties could, in my submission, an original award is made. If that's become enforceable, a party can enforce it. If an additional award is then made in respect of a claim which is separate, but which would, in a sense, lead to a set-off, then there can be a separate dispute about the status of that award. It can be challenged in court. If it's also valid, then the party who's entitled to the benefit of that award can enforce that, and the set-off happens that way. An additional award can't change what was decided in the original award, because if it does, it's not an additional award.
Well, it includes additional award in respect of a claim, including interest or costs.
Yes,
So
it takes the form of a separate award.
And you could defeat that problem by saying the counterclaim issue would be decided within 20 years, and on your case that would be valid, and you're still able to enforce it. My problem is different. I know you don't want to deal with additional claims and so on, but I was looking at the words of the arbitration agreement in tab 14, and at one stage I had thought that the logic of your case was that you simply blue penciled out the word and to amend and add and change the judgment they're given at any time. I thought, oh gosh, all of that has to go. Well, I can see how the word change may have to go on your case, because they can't change it. Although possibly we would interpret change to mean correction. But even if you change to correction, it still can't be correction at any time. But you could add to the judgment at any time in the sense of having an additional claim. So I think at some stage we've got to grapple with the words in this agreement to see whether we're interpreting them or striking them out. And if we're striking them out, which ones we're striking out. Because we can't strike out at any time for change, but leave it in for add.
Yes.
You see my problem?
My lord, I do.
Yeah.
I have two points arising from that question. The first is that what the agreement says is that the Beth Din can amend and add to the judgment they have given. And this is a construction point, my lord, but in my submission, there is a difference between adding something into a judgment that you have made, and that is not making an additional award, that is changing the judgment.
Oh, I see, right.
And making an additional award, which is a separate award, and that's that is what an additional award is clear from the default provisions.
So all of those three things, amend, add and change, mean change the thing you've already decided.
Yes, because what the agreement says is the judgment they have given, and if you look, my lord, at section 57, paragraph 7, within the default regime.
the distinction between correction and
Yes. So a correction of an award forms part of the award. It follows from that an additional award doesn't. It's a separate award, and all of the provisions in the Act dealing with corrections, challenges, whatever, they apply afresh to that additional award. So that's why the position is different
Yeah.
as regards an additional award.
So I see that. So in fact, your case is that we put a line through the words after the comma, and everything, and to amend and add to and change the judgment they're given at any time is repugnant to the clause 22 and the Arbitration Act, and you say it's inconsistent, it's got to go.
Yes, my
Yeah,
lord.
okay.
Well,
Sorry to
can
be
you
slow,
not simply
yeah.
say that what we do is we interpret to amend and add on and change as meaning correct,
Yes. So there are really two options.
and then all we have to delete are the words at any time.
That's another way
Yes,
of doing it.
Yes. So my lord, in my submission, this can be dealt with either by disregarding the term as repugnant to the agreement, or by construing it to make it consistent with the Arbitration Act.
And in terms of just on the at any time, can I just ask you this? I'm sorry you're being asked so many questions, but may I say we didn't draft this sentence, and I hope it at least enables Mr. Randall to see the questions he's going to have to confront as well. Can I just ask, at any time, that might be thought to mean that you're not stuck with the 56 days and you can be, you know, subject to applying back to court to get rid of arbitrators who are simply not doing their job, give you at any time. And then you have to go back to the default provision in 57.4, so that because they forgot to say when you had to make this application by, any application for the exercise of those powers, which include powers in subsection 1, must be made within 28 days, so that you actually save the whole of the sentence but interpret it properly, as long as you made an application within 28 days.
Yes, my lord, although, so in my submission it is necessary for there to be a point by which the award will be final.
Absolutely,
Yes, then-
I understand that, yeah.
So for
Perhaps
the
the
changes
easiest way is
themselves,
just to accept that all the words after the comma, we're distorting them so much because amend, add and change are meant to describe three different states of affairs, all of which are prohibited. So you can't really interpret them all to mean correct. And at any time means what it says, it means at any time. And perhaps, brutal though it is, a blue pencil through that bit, and they've still got the powers of default under the Act anyway. The unfairness is that poor Mrs. Endzweig wouldn't have realised she ought to have used the default powers because she was doing her level best to follow the agreement.
yes,
That's the injustice. But
Well-
you say that's not your fault, and that's consistent with the Arbitration Act.
yes, my lord, and if the parties have made an agreement in writing to arbitrate with an English seat, the Act applies, and they are within that framework, and that is there are really important public policy reasons why that framework exists, because the court is excluding its own jurisdiction in favour of these tribunals, so it must be dealt with in a way which is consistent with the Act. I can understand that the respondents would be frustrated by the outcome. It may give you, my lord, some comfort that this review was prompted by unilateral phone calls between the respondent's wife and the arbitral tribunal, and that is, in my submission, very unfair to the appellant. So there's unfairness on both sides.
Yeah, just like it going off to the court and not telling the court the truth either. Neither party in one way comes out brilliantly. But anyway, that's not for us to decide.
I'm not sure it's clear from the judge's judgment where he recounts it whether your client's communications with the tribunal were fine.
Some of them were, but my lord, yes. This is all an issue on the Section 68 application, but for context, what the appellant intends to say in the Section 68 application is that the duty of the Beth Din, of the arbitrators, to act fairly and impartially between the parties. And while both parties did attempt to communicate unilaterally with the Beth Din, I accept that, no one has covered themselves in glory. The Beth Din responded to one side and did not respond to the other. It had meetings with a witness proffered by one side, had phone calls with
So
one
you've
side.
made a Section 68 application in relation to the third
Yes,
award provisionally.
Yes, if the appeal succeeds, that
You said that's listed for April.
for April, yes, so that will no longer be necessary if the appeal succeeds.
If the appeal is lost, and even if you succeed on your appeal, then they go to award number 4,
Yes,
and we have award 5, 6, and 7
Yes.
to come.
my lord, yes, and in my submission that is,
And that's what you say is wrong, yeah.
yeah. Yes, my lords. I was taking your lordships through the reasons that the learned judge gave
Yeah.
for finding that, in fact, this agreement about changes at any time doesn't prevent the award from ever becoming final. We've dealt with the point about the Beth Din declaring itself functus officio. The first reason the learned judge gave, and this is paragraph 47, I think, of the judgment. One moment. Yes, paragraph 47 on page 49 of the core bundle. The first reason the learned judge gave was that if there had been no challenge to the second award, it would have been final. This is a short point, my lords, but the problem with that analysis is that without a deadline, a challenge can be brought at any time. If the respondents hadn't asked for a review of the award in June 2024, they could have asked for a review today, or next week, or in 5 years' time. And the Beth Din could have taken any amount of time to conclude that review. A challenge is never out of time, so the award is never final. So that's the judge's first point. The third reason the learned judge gave for concluding that this term of the agreement didn't prevent there being a final award is that if the Beth Din initiates a review and then delays in producing an amended award, the arbitrators can be removed. And that's the point at paragraph 48 of the judgment, still on page 49. The starting point there, my lords, is section 24 of the Act, which is the provision allowing a party to apply for an arbitrator's removal. And that's in the authorities bundle at tab 22. At page 345. There are 2 points to make in relation to the judge's conclusion in this respect to do with the removal of arbitrators, my lords. First, and most importantly, if an arbitrator is removed under section 24, that does not bring the arbitration to an end. The tribunal would need to be reconstituted under section 27, and I won't take you to that, but for your lordship's notes, it's in the bundle, the authorities bundle at tab 23, the next tab. Second, the circumstances in which an arbitrator can be removed are set out at paragraph 1 of section 24. And none of those, my lord, would allow a party to apply to remove an arbitrator in circumstances in which the other party to the arbitration has made a request for a review of the award, in circumstances in which such a request is indeed allowed at any time under the arbitration agreement. So an application under section 24 wouldn't prevent an endless cycle of the requests being made to review the award. And the applicant would also need to show at the bottom of paragraph 1 of section 24 that substantial injustice has been caused. The delay on its own is not enough. It's necessary to show a substantial injustice, which it may not be possible to do, but nonetheless the arbitration would be never ending.
It's also the point, isn't there, that if you can challenge at any time or seek correction at any time, then you could never challenge the award under section 70.
Yes.
Because you would always have an available recourse under section 57.
Yes, precisely, my lord. all the provisions of the Act which require the award to be final, enforcement, but also challenges to court, there would always be a defence to an application under one of those provisions, because the party would always be able to say, as the respondent said here, that it's not final, there's a review, or we've just put in a request for a review. With respect to the learned judge, he said towards the middle of paragraph 47, still page 49 of the core bundle, that repeated requests for a review in order to prevent an award from ever being final, he considered that to be a far-fetched scenario and a more notional than realistic guide to proper construction. In my submission, my lords, it's not far-fetched at all. One or more parties is very often not happy with what has been decided. And in a case like this, where one party has been ordered to pay a significant amount of money to the other party, people are rarely enthusiastic about doing that. It's very likely that if there is a power to ask the tribunal to have another go, consider some additional points, that power will be exercised indefinitely. So, my lords, those are the reasons, in my respectful submission, that the learned judge should have found that an agreement allowing the tribunal to change its award at any time was inconsistent with the final determination of the dispute. That brings me to my second submission on the first ground of appeal, which is that the learned judge was wrong to find that such an agreement was one the parties were nonetheless able to make within section 57(1). If your lordships can please turn back to the judgment, core bundle tab 5, still on page 49. At paragraph 49, in the second half of that paragraph, the learned judge found the supposed uncertainty, he found second, more fundamentally, the arbitration agreement dated December 2019 is not itself uncertain. The supposed uncertainty is not in the agreement, but is in the state of affairs obtaining as a result of an unlimited power of alteration. In my view, no question properly arises as to the certainty of the agreement. That appears to be a finding, my lords, that the parties can agree an arbitration process that will not finally resolve their dispute, but that agreement can still take effect on the basis that it is clear what the parties meant in an ordinary contractual sense. And I can take that point much more quickly than my first submission, because as I explained earlier, it is in fact now common ground that the parties to a valid arbitration agreement cannot agree to an arbitral process that is incapable of finally resolving their dispute. And again, my learned friend accepts that at paragraph 32 of his skeleton. If your lordships are with me, that an agreement that allows the tribunal to change its award at any time is incapable of finally resolving the dispute, it therefore follows, my lords, that that is not an agreement that the parties to an arbitration agreement are able to make, whether within section 57(1) or otherwise. We've already discussed to some extent the consequences of that finding, but I'll come back to that again in the final section of my submissions. That brings me, my lords, to the second ground of appeal. I deal with this at paragraphs 48 and onwards of my skeleton argument, beginning at the bottom of page 17. My lords, the learned judge was, in my respectful submission, wrong to find that section 57(1) of the Act allows the parties to agree that the tribunal can amend and add to and change its award. I have two submissions to make in this. The first is that the parties can only, by section 57(1), make an agreement allowing the tribunal to correct its award. An agreement about changes that are not corrections is not within the scope of section 57(1).
Or make an additional award in 57(1).
Yes, my lord. The learned judge decided the point by reference to a power to change
Yeah.
the award. If there is a power to correct an additional award, and I've shown your lordships what the wording is in that respect, and that it's changes to the judgment that the tribunal has made, which is a power to change the original award in my submission, not to make a new award.
On an undecided point.
Yes, yes.
So can I just ask you, in relation to this point, we know that one of the grounds on which they purported to make the third award was that, in fact, monies had been paid earlier on. And in relation to that, is that correcting an award? When I've said you must pay 900,000, oh, I've forgotten the 50,000, I'll add it back in. So it'd be 850,000, or do you say that's not a correction? That's actually a change, something that I don't have power to allow.
I say that's a change, my lord, and that's consistent. I'll take you now to
Yeah.
what the commentators and courts below. Again, I'm afraid there's not a point on which there is any appellate authority, but I'll show you what judges in the High Court have said. But just to answer your question, my lord, the commentary of the cases I'm going to show you all suggest that an application to the tribunal that it should reconsider certain evidence or look at some new evidence is not a correction. The tribunal cannot, by corrections within section 57, go outside the four corners of the award it is correcting. It has made a decision on certain evidence, and that is its decision, and it can't change that, but it can change if there was an error in how that decision was expressed, that can be changed. But I'll show your lordships the commentary. The relevant principles are summarised again in Mustel and Boyd. Your lordships will find the relevant passage under tab 35 of the authorities bundle at page 475.
Thank you.
Beginning, my lords, with paragraph 12.59 towards the top of the page, the editors there say that they are discussing the issue of what types of requests fall within the scope of section 57.3a or the equivalent provision in the applicable arbitral rules. So the editors of Mustel and Boyd understand what they go on to say in the paragraph I'm going to show you to apply to corrections generally, not only to the default regime. The principles are then set out at paragraph 12.61. Those principles are: there will be an error where the arbitrator wrote what he intended to write but was mistaken in the substance of what he wrote. This has often been described as requiring an error affecting the expression of the tribunal's thought, not in the thought process itself. However, the provisions of this kind cannot be used by an arbitral tribunal to reconsider a final award. As was noted by the 2001 companion to Mustel, provisions of this kind are not intended to enable the arbitrator to change his mind on any matter which has been decided, and attempts to use the section for this purpose should be firmly resisted. A complaint that an award was made against the weight of the evidence is not susceptible to section 57.3a, a request under that section, even where the effect of the complaint is that evidence going a particular way has not been addressed. So I think that answers my lord's point. Nor can section 57.3 be used for the purpose of obtaining an explanation of the steps taken by the tribunal in arriving at its conclusion on facts relevant to evidential issues. My lords, that is, in my respectful submission, an accurate summary of the law on this point. If I can, by way of illustration, take you through one of the cases referred to in that paragraph of Mustel at tab 4 of the authorities bundle, page 52. My Lords, this is a decision of Mr. Justice Hamblin, as he then was, in a 2012 case called Aces Havel Click. The case concerned a jurisdictional challenge to an award under Section 67 of the Arbitration Act. The defendant argued that the claimant had not first exhausted any available recourse under Section 57, as an applicant is required to do prior to making an application to challenge the award in court. The relevant passage begins at paragraph 20 of this judgment, my lords, so that's at page 55 of the authorities bundle. Can I invite your lordships, please, to read paragraphs 20 to 24 to yourselves?
So this was all a default powers case, as it were?
Yes.
Yeah, thank you.
Can I move on? Have you finished? Really? Thank you. I would respectfully submit, my lords, that those passages make good the appellant's case as to the limit to the scope of the changes that a tribunal can make under Section 57, whether by party agreement or under the default rules. As my lord says, in ACES, the court was concerned with the default wording in Section 57(3)(a, rather than with a bespoke agreement under Section 57(1). On that point, if I can ask your lordships to go, please, back to Section 57, tab 24 of the authorities bundle, page 350. And if I can ask your lordships to look again at paragraph 3a, it's clear, my lords, that the parties can agree a power of correction that is narrower than that default provision. The parties can, for example, agree that the tribunal should only be able to correct typographical errors. They can also agree that there should be no power of correction at all, and that is because Section 57 is non-mandatory, so the parties can exclude it, and if they have excluded it, there is no recourse to the original tribunal at all. What is less clear, my lords, is whether there are changes that can be made which are broader than those allowed by paragraph 3a, but which are nonetheless corrections, and which are therefore within the scope of paragraph 1. In my respectful submission, it is a little difficult to envisage what sort of change might be outside the scope of paragraph 3a, which provides quite a broad description of corrections, but which could nonetheless properly be characterised as a correction, and therefore fall within Section 57(1). But, my lords, you do not need to decide that point today, and that is because whatever the outer limits of the correction principle are, an unlimited power to change an award clearly goes beyond those limits. And that's because, my lords, such a power, by definition, allows any change at all, and would allow the tribunal to make changes that go to the very heart of what the tribunal originally decided. My Lord, that is my first submission on ground 2.
Can I just ask in relation to that, do we know factually from the judgment of the judge below or from the evidence that the parties have adduced whether or not I paid him the 95,000 before and it's just an error to have included it in the figure you've ordered me to pay was advanced before the tribunal hearing the second award, coming to the second award?
The appellant's case is that it wasn't. I would imagine the respondent's case is that it is.
Well, no doubt Mr. Randall can answer that question, but as far as you know, it hadn't been raised.
Yeah, so the Section 68 plan is made on various bases. One of those bases is that the issues that the tribunal purported to decide when it amended the award by the third award were not matters that had been before the tribunal and not matters on which the appellant had had any opportunity to make submissions to the tribunal. So my lords will have seen that the third award makes reference to having looked at the accounts.
Yeah.
That happened, my lords, during a meeting between the Beth Din and an employee of the Respondents, which was arranged without that. This is addressed in the judgment. I'll see if I can find it, which my client knew nothing about.
Well, it was just that bit in the third award which said the 95,000 we forgotten to deduct, and it was common ground, it was paid, or it says party B
Yes.
or party A agreed that. So it suggested that party A had been asked about it.
No, it does suggest that, but my lord, the appellant's case is very much that he wasn't asked about it, but that was
Right.
not something that was before the tribunal. And
Right,
in
well, we
fact,
can't get into contentious matters. I just wondered
Yes.
if there was an
Yes.
issue. Yeah, okay.
my
thank
lord, in fact, one point, this goes back to my lord's earlier comment about unfairness to the Respondents. Things have happened during this process, this arbitration, which both parties are unhappy with. But there has been an arbitration. Both parties have attended hearings. The tribunal has made an award. And if that isn't inherently unfair, my lords, it's no more unfair than if a judge makes a decision one party thinks has totally misunderstood some part of his or her evidence, and that happens, my lord, all the time. It's common for one party, and in this case both parties, to have dissatisfactions with the award that has been made. And my respectful submission, my lords, it's important not to let what has subsequently happened and what we know about those dissatisfactions from altering the correct position on the law.
In terms of what they did, if we look at their rulings, at tab 2 in the supplementary bundle, they say after listening to both parties and analysing their arguments. If you actually look at tab 11, they say following on from the ruling that they issued and after analysing the counter arguments the party B raised, there doesn't seem to be a reference to a hearing there at all. If I'm just reading the words on the page, what Ms. Potter said.
My lords,
Although I suppose they could have had a hearing, but the thing that mattered to them was the analysis of the counter arguments. I suppose we just don't know, do we?
We've got paragraph 50, the article of the reasoning, the third line. It said party A didn't deny this in court,
Claiming court,
which
yes.
is why I'd asked if it had been raised in the first hearing, because from what you've said, there was no hearings before the third award, but there was a hearing before the second award. So that's why I had inferred, obviously wrongly on your case, that this had been raised in the earlier hearing. Okay, thank you very much.
My lords, I've come to the end of my first submission on ground 2, which was to do with what a correction is and that the parties cannot, by section 57(1), agree that there can be changes beyond corrections. My second submission on ground 2 is that an agreement allowing the tribunal to make changes that are not corrections, not only would that not fall within section 57(1), but it would be contrary to section 58 of the Act, which we have already looked at. It's at tab 25, page 352. I have already explained, my lords, why in my submission section 58 does not assist my learned friend, because the parties are only able to agree a broader process of appeal to or review by another tribunal, not the same tribunal that made the award. I've addressed your lordships on what, unless otherwise agreed by the parties, means, and I've taken your lordships to the authorities, the cases that I rely on to establish that any available arbitral process of appeal or review means to a separate tribunal, an appellate tribunal, not to the same tribunal. If that's right, my lords, if you're with me on those points, then it follows that section 57 is the only provision that allows the tribunal to change its own award. And as I've explained, section 57 is, in the appellant's case, limited to allowing corrections. If the parties have agreed that the Beth Din should have a power of appeal or review in respect of its own award that goes further than allowing corrections, that agreement is then contrary to section 58 of the Act, which is a statutory enshrinement of the principle of functus officio. And that is not, my lords, an agreement that the parties are able to make. Those are the points I wanted to make, my lords, with respect to the second grounds of appeal. Moving then to my fourth and final topic, which is to address how I would respectfully suggest your lordships might approach the parties' agreement about the tribunal's power to change its award, if your lordships are with me that such an agreement is inconsistent with a valid arbitration agreement. I'll try and take this briefly, my lords, because there's been discussion of this in response to your lordships' very helpful questions. My lords, there are, I would suggest, three options as to how this could be dealt with. Before I come on to those three options, I want to make one important overarching point, which is that the parties intended to make an arbitration agreement, and they intended to refer their dispute to arbitration in accordance with that agreement. I have shown your lordships clause 22.2 of the share purchase agreement. That refers to arbitration and provides that the award made by the Beth Din will be enforceable in court as a judgment. I've also shown your lordships the 11th of December 2019 agreement, which provides that it will be valid according to the Arbitration Act, which is valid according to the laws of the government. My lords, both parties participated in the arbitration before the Beth Din, and both proceeded, at least at first instance, before the learned judge, on the basis that an award made by the Beth Din could be enforced under section 66 of the Act, although there has obviously been a dispute as to which award represents the final award. So, my lords, the starting point is that the parties made an arbitration agreement. That agreement was for arbitration in London, and therefore with an English seat. It was an agreement made in writing and governed by English law, and it is therefore an agreement to which the Act applies. And I won't take your lordships to them, but that is the effect of sections 2, 5 and 6 of the Arbitration Act, which are under section tabs 17, 19 and 20 of the authorities bundle for your lordships note. Having contracted into that framework, the framework of the Act, my lords, the parties have to operate within it. And with that in mind, I will then turn to the first of my three options as to how an agreement that is outside the framework of the Act should be dealt with. The first possibility, my lords, is that the problematic term simply does not form part of the arbitration agreement. It is something that the parties agreed, but it is not part of their arbitration agreement. To form part of the arbitration agreement, the term would need to come within section 57(1), which we've looked at many times, but again is at page 350, tab 24 of the authorities bundle. Section 57(1) presupposes that any agreement between the parties is valid in that it's an agreement that the Act allows the parties to make. If, my lords, the agreement that the parties have made is outside the scope of section 57(1) and therefore contrary to section 68, the result is that there is no party agreement capable of taking effect within section 57(1). And if that's right, my lords, then the default provisions of section 57 apply, because they apply if or to the extent there is no agreement under section 57(1).
So does that mean that the whole of page 111 is of no effect? No, you say no party agreement, the default provisions apply.
No, my lord. It simply means that on the issue of the power of the tribunal to correct its award or make an additional award, there is no party agreement within section 57(1). There may be other things in the December 2019 agreement which on some other issue are capable of forming a party agreement.
So I think this isn't a textual argument, it is, as it were, it's an effect argument.
Yes, yes, my lord. But the Act provides a framework. Once the parties have made an arbitration agreement in writing for English-seated arbitration, we are within the Act. And the Act provides a framework for the agreement, for the conduct of the reference, for challenges to the award. And the question under section 57 is, first, have the parties made an agreement within section 57(1)? If your lordships find that the agreement the parties have made about any change at any time is not one that falls within section 57(1), then, pursuant to section 57(2), the default regime applies.
Shouldn't our approach be, first of all, to look at what parties have agreed in writing and seek to interpret that before we, and this is your first possibility, but I wonder if it would
Perhaps, my lord. As my lord says, another option
So
is
this is your second option.
my second option, my lord.
Thank you.
Is to construe the power of amendment in the December 2019 agreement so as to make it consistent with there being a valid arbitration agreement. And that would involve, my lords, finding some limits on the Beth Din's power to change its award, both in terms of the timing of any amendments and in terms of the nature of those amendments. Looking at the 11th of December agreement, it's not possible, my lords, to identify from this any alternative limits, either on the temporal scope or the substantive scope of the amendment power. And if that's right, the limits must be found in section 57, because Parliament has decided that those are the limits that apply if the parties have not specified their own limit. And the effect of construing the December 2019 agreement in that way, my lords, would be in effect that it's to be read as saying the Beth Din has the authority to amend and add to and change the judgment it has given at any time, subject to the limits set out in section 57 of the Act.
We've got two choices really. One is all the words after the comma, but we could also just, strike out and add to and change, because they can't add to and change the agreement, but they could amend in the sense of correct, but then you've still got the problems with it any time.
Yes, my lord. So as to the nature of the corrections, it is necessary, I think, to read add to and amend and change as meaning
Correct.
in the sense meant by section 57(3), or some broader sense if your lordships take the view that correct has a natural meaning that is somehow broader than those default provisions.
And what about amending or adding to being analogous to the power to make an additional award?
Yes, so the tribunal, the question there first is if the parties have made an agreement which the court needs to somehow construe as to the power of the tribunal to correct an award or make an additional award, the first question is, did the parties intend their agreement to provide comprehensive provision for post-award amendments? If they did, I think it is possible, my lords, that they did not create a power to make an additional award at all, because what they have actually provided is that the tribunal should add to or amend, should have power to add to or amend or change the judgment it has given.
It's not deal with an undisputed point, which has been called an additional award. It's to bring about an alteration in that which has been handed down.
Yes, my lord.
And that you say is not acceptable, say as far as it's a correction.
Yes, my lord. So if the party agreed wording is going to remain in the agreement, but the task is to construe it, in my submission, the party agreed power does not include a power to make an additional award. And section 57, any part of this can be excluded, but if it's excluded, that means the tribunal doesn't have the power to do whatever has been excluded, not that the tribunal...
Well, I understand that. If we strike it out and there's no power in the agreement, then you're back to the default provision.
Yes.
But I think the first question is, which word or words do we try to construe or strike out? And then if we can't construe them and we have to strike them out, then you go to the default provisions.
Yes.
But I don't find it helpful to look at the default provisions and say they apply. I've got to wrestle with this agreement. This
Yes.
is what the parties agreed. And so much of it can be saved, perhaps all of it, should be saved.
Yes, my lord. So, looking at what the parties have agreed, in my submission, the starting point is that they have attempted to agree, they have agreed, that Beth Din should have a power to change its award, change and add to and amend the judgment they have given. That is a power to change an award that has already been made.
They can't do that.
And the maximum extent of that power is to correct the award. So if that's right, the agreement can stand, but amend, add to and change needs to be read to mean correct. As to any time, my lord, that does, in my submission, need to be struck through.
Yes, you say there's nothing they can do without a time limit because there's got to be a way of making it a final resolution.
Yes, my lord. So those are my submissions on the correcting an award that has already been made. On the additional award point, my first submission is that the parties haven't agreed that there should be any power to issue additional awards. So there is, the starting point is there just is no such power. That's outside the scope. They have made some agreement on this approach under section 57(1), and it does not include a power to make additional awards.
And the wording is add to the judgment, not make an additional judgment.
Precisely, my lord.
Yeah.
But were there to be a power to make an additional award, there would nonetheless need to be a time limit, so the same issue applies with respect to the at any time wording, and that's because otherwise the tribunal can continuously produce new judgments, potentially over a period of years, and again that's contrary to the scheme of the Act and indeed the public policy.
But they may not have provided for an additional award, but isn't the effect of section 57 2 that if they haven't provided for it, it will be included by way of default?
Not necessarily, my lord. There's an authority on this. Mr. Justice Fulton, as he then was, in the Czech Republic case.
The Diag case.
Yes. You find the relevant part of that judgment. It is at tab 14 of the authorities bundle. Sorry, my lord, I've marked it, so I need to find my marking. Yes, my lords. It's tab 14, page 290. This is paragraph 208 of the judgment. If I can just invite the lordships to read that paragraph.
Yes, thank you.
So, my lords, if your lordships conclude that by this agreement the parties did intend to make comprehensive provisions, proposed award amendments, then in my submission they intended there to be a power to change the award, which must, for the reasons I've given, be construed as a power to correct the award, but they did not intend that there should be a provision to make additional awards because they haven't said anything about additional
So how do
awards.
you add to a judgment without making an additional judgment?
My lord, for example, you could add a section on a new piece of evidence, a new submission that has been made in a variety of ways.
Thank you. Right, you knew we're going to have your third option now, are we? Because I'm conscious of the time.
Yes, my lords. The third option is that the problematic term can be disregarded as repugnant to the remainder of the agreement. The relevant legal principles are set out in the current edition of Chitty on Contracts. Your lordships will find that the extract at Authorities Bundle, tab 36, page 494.
Thank you.
It's paragraph 16086, my lord, beginning at the bottom of that page. If I can- 1686.
Thank you.
16086, bottom of page 494 of the Authorities Bundle. If I can invite your lordships to read that paragraph, please.
Thank you.
My lords, the main purpose of the parties' agreement was that it was an agreement to arbitrate before the Beth Din. If your lordships do not feel able to construe the amendment power in a way which gives it some real limits, the result would be, if that term was given effect, that the parties' agreement would not be an arbitration agreement. The parties would be unable to enforce awards in court, they'd be unable to challenge awards in court, all the protections regarding the duty of the tribunal, etc., provided by the Act, would not apply. And that would be contrary to the parties' expressing intention that they should be able to enforce awards in court and that the Act should apply. So, my lords, if your lordships don't feel that is able to resolve the problem by construction, or to simply find that any party agreement doesn't take effect under section 57(1), then in my submission applying the principles in Chitty, it is then necessary to disregard the term as repugnant to the remainder of the agreement in order to save the arbitration agreement. And my understanding is that these principles are not controversial, my lords, and that's why I relied only on Chitty rather than taking it to any particular case.
Thank you. I see the time. That, I think, was the end of your fourth section, but obviously you'll want to consider over lunch whether there's anything further you want to just revisit. How long would that likely to be? 5 or 10 minutes?
I think, my lord, I have reached the end of what I had planned to say.
Have a chance to reflect, and we certainly wouldn't stop you. And Mr. Randall, obviously it's always quicker to respond because all the arguments are before the court. Do you have a guesstimate for your sort of time? We're not going to hold you to it in a rigid way.
I would be hopeful that I am able to finish within an hour and a half.
Okay, well
I appreciate.
Don't worry. It in any event it would be within 2 hours, and that would leave time for a reply. Yeah, good. Thank you both very much indeed, and we'll look forward to seeing you all at 2 o'clock.
All right,